We are live.
Good morning. I just want to share my screen as soon as I've done that. We'll start. There we go. Good morning, everyone, and thank you for joining today's webinar on the CIPC Beneficial Ownership Register. Today's webinar will provide information on how the BO register system operates and offer guidance on successful completing your filing. And it will also talk to specific requirements we have for filers. I'm Elma Pinkham from the Corporate Education Unit, and I'll be our facilitator today. At the moment, you see our agenda. We have Mrs. Lucinda Steenkamp. She's a senior legal advisor in the Corporate Legal Unit. She will do the presentation on the Beneficial Ownership Register. After the presentation, we have a question and answer session. We have two colleagues that are in the studio with us, and they will also assist with answering questions. They are Mr. Chuma Zwane, a senior investigator, and Mr. Benjamin Sebotsa, an investigator. They are both from the Corporate Disclosure and Compliance Regulation Unit. We ask that you please post your questions related to today's topic under comments during the presentation. Should you have questions that's not related to the topic, please log an inquiry on the CIPC website inquiry system and send a message to the CIPC Facebook with Messenger. There are also people answering there. The recording will definitely remain on Facebook and YouTube if you want to view it again. And with that, I want to hand over to Lucinda Steenkamp. Thank you. Lucinda will just try and share a presentation. Let's just see if she can do that. I know the internet is extremely slow at the moment.
Good morning, everybody. I'm just doing the share screen thing. There we go. Can you see it? Is it visible?
Yes, we can see it.
Okay. There we go. Everybody, good morning. Lucinda Steenkamp from the CIPC Legal Division. On this very cold morning, it seems that our technology is frozen as well, so please bear with us. I'm going to keep the presentation in the current mode that it is. It just makes it easier to scroll. Otherwise, we might have an issue if that's okay with everybody. And as Alma indicated, if you have questions, post them in the chat. There are officials available to tend to those. Otherwise, we will assist with all questions after the presentation. Okay. Good morning once again. So I'm just going to take you through beneficial ownership transparency from the CIPC perspective. The CIPC participated in the FATF, the Financial Action Task Force assessments, and based on the country mutual evaluation assessment findings that was contained in the October 2021 mutual evaluation report, considered addressing those specific deficiencies relating to beneficial ownership that was mentioned in that report, specifically based on corporate vehicles available to make the information on beneficial ownership of those corporate vehicles available in a timely, accurate, adequate, and verified way to law enforcement agencies and other regulatory bodies. The feedback from the mutual evaluation report was that South Africa should revise and substantially improve its mechanisms for ensuring that accurate, up-to-date, verified beneficial ownership information is available to competent authorities. and that South Africa should thoroughly assess the money laundering and terror financing vulnerabilities of all types of legal persons, your corporate entities, including vulnerabilities that facilitate corruption in government procurement, which was a big issue. Law enforcement agency should be granted better powers to gain direct and timely access to ownership and control information for legal persons. And these law enforcement officers who investigate financial crimes be further trained about company structures and beneficial ownership as a whole. This webinar that we are rolling out today is one of many that's coming, that we are focusing on the public in general, as well as law enforcement agencies specifically. And to empower the CIPC to impose administrative penalties directly, then the CIPC should apply sanctions for failure to comply with information requirements. The role of the CIPC, the regulator, the CIPC is the regulator in terms of the Companies Act, read with the applicable regulations. The CIPC has, amongst others, the responsibility to educate on and promote voluntary compliance, to monitor compliance, to investigate non-compliance and contravention of the Companies Act and other legislation, as well as enforce compliance. The General Laws Amendment Act 22 of 2022, written into law in December of last year, amended the Companies Act to mandate the CIPC to establish a beneficial ownership register. The Companies Act Regulations Amendment was promulgated on the 24th of May, 2023. Government Gazette notice, if you want to go and look for it. It is, however, published on our website as well, which provides legal backing to the requirements of the General Laws Amendment Act and the subsequent Companies Act amendments. So the CIPC's response to the Financial Action Task Force report was that on the 24th of February 2023, South Africa unfortunately was put on the FATF grey list, which effectively means that South Africa is placed under increased monitoring while the country is committed to resolve identified strategic deficiencies in terms of that report. CIPC had to respond to the following after an action plan was issued by ensuring that competent authorities have access to up-to-date beneficial ownership information on legal persons and to apply sanctions where there are breaches in terms of these beneficial ownership obligations. That is the role of the CIPC in terms of that. The CIPC released the Beneficial Ownership Register functionality on its e-services platform on the 1st of April 2023. This functionality provides for corporate vehicles, companies, and closed corporations to submit with the CIPC details regarding its beneficial ownership status, 5% and above. I'll talk to that a little bit later on in terms of mentioned corporate vehicles. Failure to submit the required information is tantamount to non-compliance of the Companies Act, and applicable court-ordered administrative fines can be sanctioned. So just this beneficial ownership information is required to be filed. This is an obligation in terms of the General Laws Amendment Act. This act amended the Companies Act in relation to beneficial ownership and gave the CIPC a mandate to request that information to be filed as and when applicable. Okay, what is beneficial ownership? A beneficial owner in respect of a company means an individual, this is a warm body, who directly or indirectly ultimately owns that company or exercises effective control of that company, including through the holding of beneficial interests in securities, the exercise of or the control of exercise of voting rights, the right or the control of the right to appoint and remove directors, that's also a form of control, the ability to exercise control through a chain of ownership of a heuristic person other than a holding company of that company, through a body of persons, like your example, your body corporate, that's what happens when you do this from home. You have animal sounds in the background. Sorry about that. A person acting on behalf of a partnership, a person acting in pursuance of a trust or an agreement, your trustees, beneficiaries of trusts, beneficiaries in terms of an agreement, etc., and the ability to otherwise materially influence the management of the company. Now, I know that this definition of beneficial ownership is very wide, and it is the responsibility of each entity to delve deeply into contracts, agreements, any form of influence into management or control that a warm body, a person may have in terms of a company that is ultimately a beneficial owner. State-owned companies, SOCs, will also be required to file beneficial owner information unless they're exempted by the Minister of the DTIC in terms of Section 9.2 of the Companies Act. Now, state-owned companies, we all believe that it's 100% held by the state, and the Minister is therefore the legal owner in terms of our legislation. But in some instances, you have the state or government is majority shareholder, but not necessarily the only shareholder. And that beneficial ownership of others needs to be indicated. Okay, so the CIPC is a member of the Interdepartmental Committee on Beneficial Ownership Transparency. And we have been since 2015, although for some years this committee was not active. The CIPC Beneficial Ownership Register was rolled out on the 1st of April, as mentioned, and to date, I checked on that number yesterday, we received 216 successful filings on the Beneficial Ownership Register. The data received on this register will also be analyzed on a risk-based approach to ascertain trends around the world with regards to ultimate owners of corporate vehicles. The main purpose of the beneficial ownership transparency is to assist law enforcement in their fight against money laundering and the financing of terror activities. The CIPC continues to support and form part of engagements where private sector or civil society is involved and to provide clarity and certainty in terms of beneficial ownership. So just this slide is just to give you an example of complex beneficial ownership. This isn't actually very complex, but of beneficial ownership structures. You have a declaring company, and then you have another company that's 100% shareholder of the declaring company, where we have SIPU owns 60% of company A. There's a trust that owns 5%, and there is Lucia Smith that owns 4% of company A. But Lucia also owns 31% indirectly of the declaring company through a separate agreement. So as you can see, these structures can become very complex, and it's necessary to delve into these structures when starting to look at beneficial ownership of corporate vehicles. So you can have a look at that scenario and work it out for yourselves at the later stage. To give you just an easy example of beneficial ownership, Lucia Stein is an 80% shareholder in ABC Marketing Pty Limited, a fictional company and name, please. ABC Marketing would not be required to file beneficial ownership in terms of Lucia Stein because the 80% shareholding that is referred to in this example is known as information that is legal. She's the legal owner, and this is known information as shareholder. The information in terms of the above would be provided to the CIPC in the form of the Securities Register, however, Section 33(1) AA of the Companies Act. Within each company securities register, the prescribed BO information must be recorded in terms of Section 50 of the Act. In other words, this is not a separate recording or filing, but the BO information or this legal information would be indicated in the securities register of ABC Marketing and thus filed with the CIPC in terms of the legislative requirements. If, for example, Lucia Stein held 25%, we're looking at her 80% shareholding, but 25% of that shareholding in ABC Marketing she holds on behalf of Luan Smit. The 25% effectively being held to the benefit of Luan Smit, making him a beneficial owner of ABC Marketing. And this information must be declared separately. The beneficial ownership information of Luan Smit, that 25%, would also be indicated in the Securities Register of ABC Marketing as per the Companies Act requirements. So there are a lot of requirements in terms of the Securities Register and additional beneficial ownership information that must be indicated in the Securities Register and then filing thereof with the CIPC. The register itself, the submission of beneficial ownership information is done through a fully automated functionality to be updated as and when the information changes, but this shouldn't be done less than once annually. The register functionality can be found on the e-services platform. Any person can file BO information on behalf of a legal person, provided that a written mandate is in place for such a filing. The mandate forms part of the compulsory supporting documents that must be filed. In other words, this can be done by company secretaries, by auditors, by lawyers' firms, by the directors themselves, as long as a written mandate is in place. The disclosure of this register is anticipated to be an online automated process as well, in line with the existing disclosure process, with the caveat that requesters of this information will be vetted and verified, as only law enforcement agencies and regulatory bodies or accredited authorities will have access to this information. The aim of the BO register is to have a repository or a register of natural persons who own or exercise control over legal entities, and to assist law enforcement, both nationally and internationally, with relevant information when it comes to the investigation of the ultimate owners of entities and tracking issues in terms of financial crimes. The disclosure and access regime to the data, MOUs to allow for data sharing with competent authorities and law enforcement is to be done. Data sharing transparency and the requirements of POPIA must all be taken into account and applied concurrently. Online capability to access basic data to continue, data on listed and unlisted entities to be consolidated for use, and data on financial crime convictions to be also consolidated for use. So we're talking about a massive triangulation of data of all the relevant entities in order to get to the heart of the beneficial ownership of corporate vehicles in our country. Compliance, investigations, and enforcement. Non-compliant BO filings are to trigger a possible investigation and a compliance notice. There is a difference between making an error, which will be dealt with, or submitting incorrect or false information. A risk-based approach to be followed in terms of the monitoring of the BO register filings and sampling thereof. And compliance notices, administrative fines, and even disqualification of directors are some of the sanctions that can be placed on entities that do not comply with beneficial ownership filing. If there is a complaint that anybody is aware of, the normal procedure of filing complaint of non-compliance through the COR 135.1 complaints email address is applicable. Next steps for the CIPC, MOUs with registries, as already mentioned. The Commission has conducted an analysis with regards to our external companies registered and identified key jurisdictions. As you know, external companies are also required to file beneficial ownership information and engaging to conclude MOUs with these jurisdictions, while others are already in place. At the moment, we are in discussions with Zambia in concluding an MOU in information sharing in that regard. Information sharing with other regulators and law enforcement agencies. The Commission has been working with other agencies, SARS, FIC, FSCA, etc., in developing the system to collect beneficial ownership information with the objective that this information will be triangulated within the realms of what the different legislations allow. Plans for listed companies defined as affected companies in the General Laws Amendment Act. The Commission provides a separate dispensation in relation to affected companies which are listed on a recognized exchange. The purpose of this is mainly to avoid the duplication of records in that such information is already collected and kept in the records on other competent authorities like Straight and Computershare. The sharing of this information will be periodically on an interagency basis shared. This will, however, not include affected companies which are not listed on an exchange. Change management. CIPC has published several pieces of information on our website and on social media that you can go and have a look at. For example, the user guidelines published under the step-by-step guides on the CIPC website, which provides explanatory notes attached to the system itself and legislative requirements, why the information is required and what's going to be done with it. There's also guidance notes published on the website explaining who must file, what is required, frequently asked questions, and several other regulations that I've referred to, as well as several articles that has been published on this specific topic on our website and through different social media platforms. Thank you, everybody, for your attention. That is me. Thank you. Questions welcome. I see that there are quite a lot of questions in the chat. I don't know if they've been responded to by the colleagues in studio. Otherwise, with a raise of hands, we can discuss a few questions. Thank you.
Lucinda, we're putting up a few questions that you can respond. The first one says, during the Q&A, please provide the clear understanding of regulated versus affected company without referring back to the legal terminology used in section 117.
Okay, so I saw that this query. Thank you, Yvette, early on as well. The difference, there is no difference. The affected company is a different name being used for the regulated company. So the references in terms of section 117 is applicable. Where it's applicable to a regulated company, it also refers to an affected company, as well as the subsidiaries of those regulated companies is also regarded as an affected company. So unfortunately, this is a highly legislative area, and the legislation definition needs to be taken into account. Thank you.
Thank you. The next question, if your company is partially owned by a discretionary trust, example 60%, how is the 60% BO filed while the beneficiaries are not named? Is the 60% split based on trustee control?
Okay, thank you, Craig. This specifically, the BO register that the CIPC has launched is very high level. The system does allow for a disclosure form where there are other entities where we are dealing with complex structures like trusts, like partnerships, etc., that needs to be indicated. There is a disclosure form on the BO system where that information can be provided for. But one of the legislations that was amended in terms of the General Laws Amendment Act was the Trust Property Controls Act, which requires beneficial ownership in terms of trusts to be filed with the Master of the High Court as well. At a later stage, once we are getting going and everybody is on the same page with regards to beneficial ownership, we are looking at a triangulation of all of this data so that the information on BO filed in terms of corporate vehicles with the CIPC and where there's complex structures related to trusts involved in those, where a trust is a shareholder of a company, for example, and the beneficiaries of those trusts had to be declared with the master to triangulate all of that information so that there is a pattern that can be discerned from that specific information. So in terms of the Trust Property Controls Act, it is important that everyone that provides a benefit or that receives a benefit is regarded as a beneficial owner. Your trustees, the beneficiaries in terms of the trust, etc. Thank you.
Thank you. Before we continue, I just want to mention many people ask where they can get a copy of a presentation. It will be posted on our website under webinars with a copy of today's recording. Our next question, do we need to disclose the beneficiaries of a trust as beneficial owners or to the trustees only?
Thank you, Anne. Yes, the beneficiaries of the trust as well as the trustees are required to declare with the master as beneficial owners. I just want to add before we deal with the next question as well is I think that, Alma, we will publish the user guide that I referred to in the change management links. We might be able to publish that as well. I think that it helps a lot with regards to legislative requirements and how that fits into the register itself. Thank you.
Okay, Lucinda, anything you want me to ask Ritzani to publish, you can just send to me or to Ritzani and we'll then have him publish it. Our next question. Part of a supporting documentation, we require to submit a beneficial interest register and a beneficial ownership disclosure form. Where can I find a template for these?
Okay, thanks, Natalie. The beneficial interest register is not something that there's a template for. The legislation specifically indicates what type of information must be contained in that register to be held by the different entities. So the templates might differ for different entities, but there is a thread of the required information that must be indicated. So just go and have a look at the legislation itself, which indicates specifically what type of information needs to be indicated in your beneficial interest register. And the beneficial ownership disclosure form is the form that I discussed earlier, where you have complex BO structures, where there's a company that's a shareholder of another company that has a trust as a shareholder. Only that high-level information needs to be provided at this point in time because that it needs to be disclosed at other levels like the FAC, like trusts, if applicable. And that information will be triangulated at a later stage. And as we build and enhance our system, that information will be able to be submitted with us specifically as well. Thank you.
Okay, the next question. I lodged a BO application on 25 May 2023. I never received the OTPs via SMS, only email. When I click to resend the OTPs, I get an error. I lodged a query, but with no response.
Thanks, Joe. I think with regards to the system, you will probably be required to submit that filing again. What we're going to do is there's a lot of filings that stop at the OTP stage and then they just lie there. So at some point in time, we're going to delete those filings and require them to be resubmitted. The problem with the OTPs is the network. Unfortunately, if the cell phone network is not running optimally, then the OTPs don't go through, etc. What I can share with you, which is good news, I think you'll receive it as good news, and you are the first to know, is that the CIPC is planning on rolling out an enhancement to the system shortly, which will require OTPs to only be sent to the filer. So you're not going to have a situation where 50% of your directors need to input the OTPs that they received. All of the directors and all of the members of the CC will receive notification of the BO filing, so they will all be aware of it. But it's only the filer that's going to receive OTPs and submit them. And we hope that that is going to alleviate the issues that we've had with the networks due to load shedding. Unfortunately, it's a bad word at this point in time, but it's reality. Thank you.
The next question. I'm unable to access beneficial ownership on e-services. There is no response on the site when I click it on both Chrome and Edge browsers.
I'm sorry, Wouter. Unfortunately, I can't answer that question. As I said, we've had successful filings. It also depends on when there's the most traffic. I think on the system, it's also the same time when we have validation issues with Department of Home Affairs. I think your best bet would be very early in the morning or after 2 in the afternoon to do this type of filing. Between 10 in the morning and 2 in the afternoon is when the heaviest traffic is on the systems, and this may affect accessibility.
Okay, what about CCs? Where trust is the member?
That information is still indicated. Remember, your trust as a member on a CC is the legal owner. That's known information. It's on the CIPC records. We know that a 123 Trust is a member of ABC Marketing Close Corporation, for example. But that beneficiary information in terms of the trust is what needs to be disclosed with the Master of the High Court in terms of their beneficial ownership filing requirements. Later, we're going to enhance our systems, definitely. This is a process. We are already busy with phase 1B in development, etc. We're going to allow for that information to be submitted as well. For now, just the information as is. Thank you.
Thank you. The next question, the company registers that must upload to BO database. Must that include history way back to inauguration of an entity or just the current BO information?
The current BO information, Jacqueline, we require the information as it is now, not history information. What's part of the enhancements that's coming as well is to provide for effective date. So if a beneficial owner became, we don't want, if he became a beneficial owner in 2012, but he's still a beneficial owner, then that information needs to be filed because it's part of the current information. But the effective date will then also be indicated, also part of the enhancements coming. Thank you.
Okay, in terms of a beneficial interest, how do I file the securities register for listed entity?
That register is an extract as far as I remember, and that is filed with your specific exchange for listed entities, and that's where the tick box of affected companies come in, that it's not required to be filed with the CIPC, but that there is confirmation that you are an affected company, and that information will then be triangulated at a later stage. Thank you.
Then Section 10(2)(b) of the Companies Act exempt non-profit companies from complying with Section 56 of the Companies Act. I'm not sure if that's a question or just a statement.
It's a question statement. I've received one of those queries as well. Thank you, Richard. What needs to be noticed is that all of these legislations needs to be read as a whole. So Schedule 1, again, of the Companies Acts, I'm looking for it specifically. Schedule 1. So go and have a look at that. But Schedule 1, Item 1, where are we? Schedule 1, Item 1, 2 2 says that a non-profit company, subject to paragraph A, may acquire and hold securities issued by a profit company, or directly or indirectly, alone or with any other person, carry on any business, trade, or undertaking consistent with or ancillary to its stated objects. So we have a situation where a non-profit company can be the shareholder in a profit company. So that is beneficial ownership information that needs to be declared there, because who are the end beneficiaries in terms of these NPCs? The members, which are your beneficial owners, and that information needs to be declared. Also, Schedule 1, there's an indication. I'm just going to look for the specific one where it indicates with the securities register. Oh, yes, it is Schedule 1, Item 1, Paragraph 9. If a non-profit company has members, the requirement in terms of Section 24(4) to maintain a securities register must be read as requiring the company to maintain a membership register. And with regards to the filing of securities register, so do filing of the members register is required. So there are a lot of requirements in terms of NPCs coming in. For example, body corporates are specifically mentioned in the General Laws Amendment Act, which is more often than not non-profit companies, and they are considered beneficial owners. That information must be filed. Thank you.
Okay. If a company is 55% owned by one shareholder and 45% by 10 others, each owning 4.5%, non-disclosable, will the system allow only 55% declared? If the system requires 100%, how must the 45% be completed?
Thank you, Craig. Yes, the system will allow the only 55% to be declared, because we are aware of the fact that there will be beneficial owners below the 5% threshold. The 100% aggregate is just to ensure that there isn't more than 100% declared, but it will allow for the 55% to be submitted. Thank you. Alma, you're muted.
Yes,
Oh,
sorry. Yeah, does this include an external trust that owns a South African company? What information would the CIPC require in that instance?
So again, if we're talking about trusts, that information needs to be filed with the master. If there is a South African company with an external trust, then that information is disclosed, just the trust name on the complex structure disclosure form. Later on, that information, because we are going to triangulate internationally as well. We are already in talks with international registration houses. There's already MOUs in place with UK, with Seychelles, other entities where we have specifically external companies on our records with those jurisdictions. So this is a process. For now, it is the responsibility of each company to check what is required of them in terms of the legislation and to tend to the filing accordingly. Thank you.
Okay, is it a requirement for listed entities?
Listed entities are not required to file beneficial ownership information. However, that listed entities are your affected companies if they fall within that definition of regulated companies. But there are requirements of the records that they have to keep in terms of the new legislation as well. So in-house, they need to ensure that their houses are in order. Thank you.
This one is related. It says, please speak specifically to listed entities and how a public register with nominee structures be uploaded.
Samira, you would have seen in my presentation, I specifically mentioned where entities are going to, where we're going to triangulate with authorities such as trade, such as Computershare, with the stock exchanges where that information is already there, so that we can triangulate and do a type of data sharing and pull that information in where it is already there, so that there isn't a requirement for duplicate disclosure.
Thank you. How far up the chain does it go? Does this include external foreign trust and or companies that own the South African entity?
This goes all the way, Lebone, to that warm body that ultimately owns a corporate vehicle or controls in terms of the definition. So these structures can be very, very complex. They can be very simple. They can be very complex. But when you whittle it down, you need to get to that person that derives a benefit, that warm body that derives a benefit, and works into this ownership structure of specific corporate vehicles. So it can go all the way to that person that derives a benefit at the end of the day. Thank you.
This person said, this is not making sense. Please clarify when BO must be filed. I'm not 100% sure to.
Yeah, I don't understand the question. Beneficial ownership, Lynn. Beneficial ownership must be filed in terms once the regulations came into operation on the 24th of May. All entities need to file their beneficial ownership in line with those requirements, and this has to be done annually. For now, we want everybody to file their information, and then from next year, together with the annual returns, this is going to be an annual occurrence where this information needs to be updated. If it doesn't change, then it's just a confirmation that the information is still the same. And if it does change before that annual anniversary with the financial year end, then that must be filed as well. The legislation and the system provides for that. Thank you.
Okay. When does an individual who holds a beneficial interest or voting rights control the company? What level of shareholding or voting rights?
Unfortunately, that's not something that we can answer. That is only something that the company itself would know, in what form that there is control or ownership in terms of that entity. I think that's on a case-by-case basis. It's not something that we can answer in terms of a general question.
Okay. On what basis do you interpret the ultimate owner of a company as a holding of 5% of the shares? How does a 5% holding equate to legal ownership of a company as opposed to ownership of the securities? The definition does not state that a 5% holding equates to ultimate ownership of a company.
Correct, Ricky. The definition does not indicate that. There is different thresholds in terms of different jurisdictions. The UK, for example's level is at 25%. South Africa's mutual decision was based on 5% because of the 5% beneficial interest threshold, and it was decided in terms of the legislation to keep it to that for uniformity.
Next question. So even members of the CC or directors of a company are the only beneficial owners and have 100% ownership, nothing hidden. Do we still have to submit?
In that instance, Vanya, if there is only legal ownership, because, for example, you have a private company that has only one director and is 100% shareholder, and there's no other person that has any benefit in terms of that company, so there's no contract, there's no dividend that's being paid out to anybody else, then that information is where it stops. Then there isn't beneficial ownership information, and only the securities register is then filed with the CIPC.
Okay, the next question, where do I file the security register on CIPC?
It's in conjunction, Karen, with the BO filing system. So you will see when you proceed where all the information is submitted, it will request the securities register to be uploaded, and that's where you input the information.
Okay, now is the 6 months transition period still in place, or do companies only need to file within 30 days after the anniversary of a company's incorporation?
The 6-month transition period is not legislated. What the CIPC intended with the 6-month requirement that we provided initially was to provide entities with enough room to and enough time to get their houses in order while we were waiting for the regulations to be promulgated. There is no legislative 6-month period, so the requirement to file is in terms of the legislation. So they shouldn't look at the 6-month period because it's not legislative. There's no transitional period. It was just a way for the CIPC to get everybody started while we were waiting for the regulations and the legal backing to request that information.
Okay, the next question, are companies that do not have BOs still expected to submit documents to the CIPC stating same?
And in instances, remember there's additional requirements, not just in terms of beneficial ownership. So there's additional requirements of securities registers and beneficial interest registers that needs to be filed with the CIPC. If there's no applicable BO information, the securities register is still compulsory. Every company needs to have that. And if you're an MPC, you have a members register. If you're an MPC with members, and that information needs to be filed as well.
Okay, once the BO information is updated, will this information appear on the disclosure certificate of a company?
The BO information will not be indicated on the disclosure certificate because this is currently treated as confidential information. What we are intending on developing, it's part of the enhancements to come, is that a disclosure certificate for an entity will show that they are BO compliant in the sense that beneficial ownership information was filed, but content of BO will not be indicated, no.
Okay, how can a company be held responsible for delays caused by Gov auditors?
I cannot answer your question.
Okay, the next one, please explain. Section 56 of the Companies Act only requires affected companies to keep a beneficial interest register, not a register of beneficial owners. The definition of beneficial interest differs from the definition for beneficial owners.
Okay. I understand that everybody needs to find out how BO works, but unfortunately, I cannot use this time to go into legislative explanation. What I do want to urge you is to go and have a look at the user guide that has been published on the CIPC website, where legislative requirements are explained and the difference between beneficial ownership and beneficial interest, where it needs to be filed, when it is applicable, etc. So please go and have a look at that. I'm sorry, Ricky, if you'll forgive me for that now, but if I go into legislative requirements, then we're going to be here until 4 o'clock.
Okay, the next question, section 117 and 118 of the Act may cause a lot of private companies affected transactions. Will they be deemed as affected or regulated companies?
Again, legislative queries, it's not for the CIPC to decide which are an affected company or not. They have to look at the legislation themselves. It remains the company responsibility to see where they fit into this requirement.
Okay, this is a request to please publish examples of a form to show BO. I don't think that's a question. Rutsani, next question. It says, and then you have to wait for such appointment, another delay. Does CIPC take this into consideration?
I don't know what such appointment is. I suppose this relates to the government auditor's query. Again, it remains all those entities' responsibility. If CIPC cannot take responsibility, unfortunately, for entities that do not submit timeously. If there are reasons provided for why this is done, then that can be dealt with on that basis. But unfortunately, the query we can't help with on other entities in terms of their requirements.
Then the next question, are you going to make a drop-down menu for different classes of shares? We have a scenario where a company is listed, however, it does have pref shares that aren't listed.
No, we're not going to make a drop-down list of shares. There's going on the BO system, there is a drop-down list of the type of beneficial ownership. So this can be voting rights, this can be shareholding, this can be control, direct, indirect. So there is a drop-down list for all of those requirements, but the different share changes will form part of the securities register that is uploaded, and it's not input as data into the system.
Okay, how can you publish guidelines when you have not yet promulgated the regulations?
The regulations were promulgated on the 24th of May, 2023. And the guidelines was published after.
Okay, and then there's a question. Please advise in the event the ultimate owner is in the New York Stock Exchange.
Is the ultimate owner a warm body? If it is part of the complex structure, then that also all that information needs to be triangulated. If the ultimate owner of a South African company is listed on the New York Stock Exchange, then that is part of the beneficial ownership structure and needs to be disclosed as such.
So please share a practical example of filing and in which format are these registers to be uploaded.
Okay, so all of that information again is on the user guideline, which is a step-by-step guideline of the system. It shows you screenshots of what the beneficial ownership register look like, as well as the documentation that must be uploaded. As indicated, there's no template for the registers, but it will have to be uploaded in PDF format so that it cannot be amended in any way, and that is the format that the CIPC accepts documentation in.
Okay, how does CIPC intend to handle the DHA system that is not verifying the IDs of a BO?
The Department of Home Affairs integration is a general issue with the CIPC, unfortunately. It sounds like an excuse, but it's not our fault. We have the same issue with the filing of any other filings on our different e-services and biz portal platforms where we have DHA validation issues. We are actively working on upgrading the situation in talks with Department of Home Affairs. But what we have built from our side is that should a person not be able to validate while they're filing their ID because DHA is down, then that person will be allowed to save the filing and the validation can be done at a later stage.
Okay, is there an error while submitting with regard to the OTP sent through? Can it be reset for a new submission?
Yes, as far as I understand the system, if there's an error with regards to any part of the OTP or validation error, a new filing can be done.
I think the next one is just I think it's more a request.
I understand. Yeah, I tried to build in a few practical example of beneficial ownership in the presentation about the shareholding. Those are just one of many. Just to add to that, we are internally actively working on additional articles, working on additional step-by-step guidelines. We are working on building around examples that of BO information that we've received, and we will put those in the public domain to assist these entities in filing beneficial ownership as far as possible.
Okay, another matter is a 20% shareholding where each shareholder only holds 4%. So we look at the 20% collectively, or do we need to report on this?
I don't understand. If how do you have 20% shareholding but only 4% that each shareholder holds? I think at the end you don't look at it collectively. You look at the warm body that holds the beneficial ownership of that shareholding. That's only 20%. I take it available. And if that is divided into 4%, then the shareholder information will be of those four of the people holding 4% shareholding, but that is a legal owner. That's not a beneficial owner. And that information will be in the securities register. So there's no threshold in terms of your securities register. Any entity that has issued securities has to indicate that in their securities register, whether it's a 0.5, whether it's 1%, whatever the case may be in terms of shareholding, that's indicated in your securities register, and that's uploaded as well.
Okay, if a foreign public company with several shareholders owns a private company in South Africa, must the foreign shareholders be included in the beneficial ownership or just the directors of a foreign company?
If a foreign company has several shareholders and they own the private company in South Africa through their shareholding, I take it, then those shareholders of the foreign company would be the beneficial owners of the private company in South Africa. Again, always whittle it down to the warm body at the end of the line. They are in effect in person the true owners of the private company in South Africa, and that information needs to be declared. A director is not a beneficial owner. That's also a part of the management of the company, and that is known information. If there is somebody in terms of the directorship that pulls the strings, that's not indicated as a director, but they have, for example, the power to appoint directors or remove directors, that's control, and that's beneficial ownership.
Thank you. Then what is the basis for your statement that the obligation extends to external companies?
It's contained within the General Laws Amendment Act as well as the promulgated regulations. This BO information must be filed by external companies as well.
Okay, please advise what you do in circumstances where you have a company in South Africa that is owned by a listed company in Germany. Who is the BO? So 3,000 shareholders of a public listed company.
If those 3,000 shareholders all have more than 5% shareholding, then yes. Remember, you have to work at the aggregate of 100% in terms of shareholding or beneficial ownership of a specific entity. So you can't have 3,000 shareholders being the owners of a company through a specific shareholding, because it's impossible in terms of the shareholding calculation. So all of that needs to be taken into account.
Okay, how will you know who are subsidiaries of a listed company?
We won't know. That's again the responsibility of the companies to file that information.
Okay. Who should be the owners to get the information from listed entities? What happens in case of funds holding shares in listed entities? These funds have multiple legal persons. How do we get that info?
I reiterate that the responsibility lies with all these different entities to tend to their governance requirements in terms of beneficial ownership information. So, if you, as a company secretary, as a secretarial house, as a lawyer, as an auditor, is instructed by a company to file the beneficial ownership information on behalf of that company with the CIPC, you must be provided with a mandate in writing to do that. And we then assume, if you are instructed to do that filing, that you will be provided with all the information necessary to do the filing. It's not for different persons to go and look for that information from the entities. It remains their responsibility in terms of their governance.
In the next small statement, it says, yes, please do a tutorial on how you submit the info from start to end.
Okay, so there isn't a voiceover tutorial on how it works, but the user guide on the CIPC website shows you the screenshot of what it looks like and gives you an explanatory note on why we ask for what we ask for and the legislative requirements attached to that. If you have that user guide open next to you while you're doing a filing, you should be fine in navigating the system.
Okay, what is the case when the beneficiaries of a trust is a class of persons rather than a number of natural persons?
The beneficiaries of a trust, if they are a class of persons, there still needs to be a warm body at the end of the line that receives a benefit from that trust. And the trustees, in that regard, for example, is also regarded as beneficial ownership because they have control over the trust. So all of that information, the natural person information, needs to be provided.
Okay, is the mandate to file the same as the normal power of attorney that we use to file on behalf of clients?
The mandate can be in the form of a power of attorney. It can be in the form of a special resolution passed by the company, given to a specific person or firm or whatever the case may be. But this must be a person because they are going to receive the OTPs to file the information on their behalf. So it can be in any format. There's no prescribed requirements on what the mandate looks like. What is required is that it must be in writing. It must be clear that it is from the entity on whose behalf the information is being filed, and it must be signed.
Next question, do we only submit trust beneficial owners to the master? And what do we submit to CIPC?
Okay, so the trust's beneficial owners, if you have a company registered on the CIPC records that only has trusts as shareholders, that information will still be indicated on the securities register, number one, and on the BO register. When you're filing on that disclosure form, you will indicate that Trust 123, Trust 456, and Trust 789 are the shareholders of this entity, and that information relating to those trusts will then be filed with the master.
Okay, is it only the companies that are registered after April 2023 that we need to lodge with a long process, and all companies before that only get lodged with the ARs?
No, at this point in time, all entities need to file their beneficial ownership, whether you were incorporated in 1920 or whether you were incorporated in 2023. For now, there's this first push in terms of the legislation and the Financial Action Task Force requirements is that all entities need to get their beneficial ownership information up to date and file with the CIPC. Thereafter, this information will be updated annually by all entities, the same as annual returns, or as and when it changes.
Okay, next, in the beneficial interest and owners register, how do we disclose the listed and state-owned entities? Do we need to disclose interest in excess of 5% as well?
Yes, in terms of the legislative requirements, there is specific indication of the information that must be contained in those beneficial interest and company securities registers, and that information is filed with the CIPC.
Okay, what is required for NPCs if there are no members?
What is required from the NPCs if there are no members? You have to look at who benefits in terms of an NPC. So where you have a situation where you have a body corporate that the NPC is registered as a body corporate, or the body corporate is registered as an NPC, I beg your pardon, there are certain remuneration requirements in terms of these body corporate members, which in actual fact is a gaining a benefit from this body corporate, and it's specific, and they control the NPC. So there are specific indications, and that information will then need to be indicated as well. If the body corporate members differs from the directors, even if there's no members, if you have an NPC without any members, then there is reporting requirements in terms of the Department of Social Development, where in the NGO legislation was also amended by the General Laws Amendment Act. So it's very important that when you go through the General Laws Amendment Act, you look at all 4 legislations that was amended by that act. The Companies Act is just one. The Trust Property Controls Act is a second, and then there's MPO legislation that was also amended with much stricter requirements in terms of NPC, so that needs to be looked at. And then the FIC Act was amended accordingly as well. So it is very important that all 4 of those legislations are looked at and the amendments that apply to each of them.
Okay, thank you. How do we disclose the subsidiaries of a listed entity? How will CIPC know that the entity falls under a listed entity?
I think I sort of answered this query already. Subsidiaries, we take it from the governance point of view that this remains responsibility of each entity. I think I've said it now a few hundred times, is that the register also will indicate that if you at any point provide false information to the CIPC, you can be prosecuted in terms of Section 214 of the Companies Act. So this governance requirements, we are not going to babysit any company. There's not going to be any hand-holding. These requirements are in terms of their own governance requirements, and those companies need to declare that they are an affected company in terms of their own definitions, and the CIPC will accept it as such. Once we start with the analysis of the data that we are receiving and there's anything that doesn't make sense, then we will reach out to these different entities for more information. If we see that it was only an error or a mistake, then opportunity will be provided to correct it. If we see, however, that there was deliberate false information provided, then the sanctions can kick in, as I said, criminal in terms of Section 213, as well as even disqualification of directors if there's negligence.
Thank you. The next one, Ms. Steenkamp, you know your stuff. Thank you.
Thank you, Albert. I appreciate it. We are all still learning. Let me just tell you, I've gone through this legislation 112 times already, but I still read things that I didn't know in the previous. So we are all still learning as we go along. And rest assured that, again, I want to tell you, we are putting as much information out there as we can. You can have a look at our website continuously. We are putting out articles, we are publishing guidelines, we are putting guidance notes there. We have a dedicated query resolution beneficial ownership team set up that will answer your questions as far as possible in terms of the legislation, etc. But we hope to provide you with as much information as and when we can.
Okay. How do you legal get the position that where a trust owns the securities that the beneficiaries are owners, when legally the trustees are the owner and controls the securities?
Because the beneficiaries of that trust are supposed to receive a dividend of those securities and not necessarily the trustees. So the trustees needs to be declared because they are, as you rightly indicated, they control the trust. But why are you going to be a beneficiary of a trust if you don't benefit? And thus you're a beneficial owner.
Okay. Then this one, but trustees do not necessarily benefit from the trust, especially the independent trustees, other than a fee for services rendered.
There's where we get to the trustee again. So there's no benefit necessarily, but they control the trust. And beneficial ownership is linked to control as well as ownership.
Okay. If a discretionary trust is an external foreign trust, is the UBO where the trustees will be sufficient to disclose in this regard?
Let me just go through that one again. If the discretionary trust is an external trust, is the ultimate beneficial owner. So the external trust is the ultimate beneficial owner. No, the query is gone.
Let's put it back. It's back.
Will the trustee be sufficient to disclose in this regard? I have to reiterate, you have to take that specific complex structure and whittle it down to your natural person, to your warm body at the end of the day. Does Lucinda Steenkamp affect any control in terms of this trust? Yes, beneficial owner declare. Does Lucinda Steenkamp receive any benefit in terms of this trust that is a shareholder of this company, that is a shareholder of that company? Yes, Lucinda Steenkamp is a beneficial owner. That must be declared. So keep asking those questions of the natural person. What type of benefit do they derive from these corporate vehicles? Even if it's a long line of complex structure, that ultimate beneficial owner person is the warm body, is the person that is a beneficial owner, and that information must be declared.
Okay. Do we have to disclose the shareholders who hold different share classes and or redeemable, etc.?
No, the shareholding is it does. We don't look at the different types of shareholding or what type of shareholding in different classes. It is just shareholding is indicated in your securities register. And in the securities register of a specific entity, it will be indicated that that person holds 25% ordinary shares, or that person has 25% of preference shares, whatever the case may be. That information is detailed already in the securities register that these entities need to keep up to date. And when that's filed with the CIPC, then we see that information as well.
Okay, thank you. How will we know a BO filing was successful? Because if we click download, it gives us an error.
That is a system error. Then, if it doesn't want to download, what our technical team has indicated, if it doesn't want to download immediately because there may be a problem, again a network issue, then that can be downloaded at a later stage. So that certificate is your confirmation that the BO information was filed. As I said, that will not be available to any member of the public, and you cannot access it through disclosure, etc. But you will be able to download it even at a later stage.
Okay, how and where on CIPC do you upload or submit this register?
This goes through the BO filing, which is available on the e-services platform. It will show beneficial ownership. Again, have a look at the user guide. It gives you an indication of when and how that different registers need to be uploaded as well.
Okay, the next question. We are an MPC with over 11,000 members. Is there a way to just upload our electronic member register, or are we now required to capture all the information manual on CIPC?
Remember, when uploading your securities register, that does not mean you are indicating any BO information. So we are working on the system to ensure that once you go through the different steps, it's on the same register. So it's the beneficial ownership register. But if there are no beneficial owners in terms of this entity, and then it's only the upload of the electronic member register, then that information is submitted. So there won't necessarily be BO information. You don't have to capture it manually, just the upload of the register.
So if a trust is a BO, you only state the trust name because CIPC will link through the master information.
Correct. So if we have because we are not going to do anything from our perspective with the trustees, etc. information, we cannot validate any of that information. That needs to be filed with the master. The only thing that we're going to do is we have been indicated that there's a trust that is a shareholder or whatever the case may be, and then yes, as you indicate, at a later stage, that will be triangulated with the master's office. That will be a form of validation of the information. If we have 3 points of entry to validate against, the banks, the master, and the CIPC, then law enforcement, if it should become applicable in terms of money laundering, etc., will have 3 points of triangulation of data.
Okay, if a CC only has natural members, do they still need to submit the BO as CIPC already have all the details?
That is that if there isn't any applicable beneficial ownership information, again, that is your own governance process. If there isn't any beneficial ownership information to declare, then it isn't declared. Then you are still in compliance of the Act because the members are legal known owners, and then there's no BO information. But that is not for the CIPC to say, that's for each of these entities to ascertain.
This one, but do external foreign discretionary trust apply in this instance? Who do we disclose in the instance, and are the trustees sufficient? I don't know if we haven't done something similar.
We've had that query already.
How do we know if a beneficial ownership or securities register has been uploaded successfully? Will we receive a confirmation?
If you submit it once you have filed the BO information on the register and upload the necessary documents, the system gives you an indication that that we have to confirm, are these all the documents that you want to upload, where you confirm and then you submit. So it won't allow you to go any further if all the required documents haven't been filed or uploaded.
Okay. Do I understand correctly that if a company A's shareholding is 50% each for person A and person B, then we do not need to file a BO, or is this only the case with one majority shareholder?
That's correct. If you have a company with two shareholders, both holding 50%, and these shareholders are your ultimate shareholders, your ultimate owner, this is a legal owner, this is a known owner, there's no one that has benefit in terms of their 50% shareholding, then there's no need for BO filing, but the securities register filing still needs to be done. That's a completely different requirement. So every company must submit their securities or members register.
Okay, please kindly advise if and when the register will be made available to private sector, especially accountable institutions. Access would significantly improve ML/TF risk mitigation efforts.
Yes, that's the whole point of the beneficial ownership register, because of the fine line between transparency of this type of information and to lift the corporate veil, so to speak, and the right to privacy in terms of POPIA and other legislations. It's a very fine line. The South African government decided that this information is not going to be made available to the public to protect that privacy laws. It will be made available to law enforcement agencies and accredited authorities and other regulatory bodies like SARS, like the banks, like FIC, FSCA. All of those entities will have access to, and all law enforcement agencies, both national and international, will have access to this register and the information, but there is going to be a vetting process in terms of who will get access. It's not just submitting a letter on a letterhead and here you go. There's going to be very strict vetting requirements in terms of who gets access and who doesn't. But this register is not in the public domain. We are looking at working very closely with law enforcement, specifically in achieving exactly that, and which is the final outcome for the Financial Action Task Force is to prevent money laundering and to stop the financing of terror activities.
Okay. What exactly do you mean by known information? Does this mean all information already recorded in the securities register? Do we need to also submit this on the CIPC as a separate requirement?
Yes, with known information, I'm talking about legal known information. So if I'm a shareholder in a company, if you look at my example of the presentation earlier, where I indicated where Lucia Steyn was a 80% shareholder of ABC Marketing. That is known information. That's she's the legal owner basically of that company because of the 80% shareholding. It's not, there's no other warm body or any other person that benefits from her shareholding. That's the known information. But that 80% shareholding is going to be indicated on the entity's securities register, which must be updated regularly and filed with the CIPC, which will be done annually after we've done this full push of all the entities doing their BO filings first. But however, if that 80% shareholder holds 25% of that, she is in her name, 80% is in her name, but 25% actually belongs to Luan Smith, who doesn't want his name to be recorded because he's a prominent prince in whatever country, that he's the beneficial owner and that information needs to be disclosed. So we're looking at the known information, and then the beneficial ownership information at the end of the line as well, if and when applicable.
Okay, next question. Does the process allow for the filter to confirm that the entity is an affected company and thus not required to file the BO info?
Short answer, yes. There is a tick box on the system which allows for the company to indicate that they are an affected company and do not need to file the beneficial ownership information. In that way, the CIPC also has a record of affected companies, which again can be triangulated with the different exchanges, etc.
Okay, this one is both a question and a statement. How many companies and closed corporations are registered? And if you say 255 were successfully submitted, it indicates there is a problem.
I don't think there's necessarily a problem. Remember, BO is not going to be applicable to every single entity on our register. And with the securities register, etc., all of those filings that needs to happen, this is going to be a process. The system is obviously not going to handle 3 million submissions in 2 weeks' time. So this is a process. While we are not advocating to leave this to the last moment, the CIPC will allow for sufficient time for entities to submit the required information. The regulations were only promulgated 2 weeks ago, which is the legal backing for the CIPC to request this information in the first instance. So all in good time. I think the amount of filings that we've received already is actually a good indication of our country as a whole sitting up and taking notice of the requirements and doing their best to get their filings in order.
Okay. I was told by someone at CIPC that when lodging a subsidiary of a listed entity, all we need to do is tick the affected company box and CIPC would take a note of the company's standing. This does not work. How will CIPC attend to this? How do we disclose subsidiaries who belong to a listed? I suppose listed it must be listed entity.
Yes, to a listed entity. If it doesn't work, then a query needs to be submitted through the query resolution system and ICT. Unfortunately, I cannot answer technical questions. So if the button is there, the tick box, if it doesn't work, then the necessary queries must be filed.
Okay, the next question.
I'm sorry, Elma. I think we have about 3 minutes left on our time. No, we don't.
We've got longer.
Okay, we have time. All right.
We have time. Okay, so the next question, should we update the BO information as and when it changes or only annually when filing the annual return?
Thanks, Anna-Marie. The legislation indicates that it must be updated as and when it changes. And if there are no changes, at least annually.
Okay, and the next question. I put one up if you don't. Oh, there's one. Is there an organogram that needs to be submitted? What are the requirements here, if any?
No, there isn't. As I said, this is something completely new that the country is dealing with. So we are building the system as best we can in terms of the legislative requirements as well. So there's nothing specifically on the requirements are set out in the legislation, but there's no set template or organogram on what the structures need to look like, etc.
Okay. The next question, if a client has 65% shareholders who hold the total of 100%, but each individual shareholder only holds 1.1% each, what do we do in that case?
If those 1.1% shareholding the final link in the ownership chain, then there's no need for declaration of beneficial ownership because it's below the 5% threshold. But those 65 shareholders will be indicated in the securities register. That also needs to be filed.
Where would it end for public or private company that is ultimately owned by a listed company?
I think it's also a duplicate query. I feel like I've answered some of
Yeah,
these
quite a few
already.
times.
Yes. And
Is there
please, everybody, no technical questions. I'll try and help in general as far as possible, but I cannot answer specific entities of shareholding of what if this, what if that. Please have a look at the legislation. It'll help a lot in deciding on working out exactly what your beneficial ownership structure looks like and to have that filed.
Okay, this might also be a duplicate, but can the BO register be filed as a standalone filing, or is it required to be filed in conjunction with annual returns?
Yeah, I think it's this sort of the same thing as I said. We want the BO registers to be updated for all entities applicable now in terms of the legislation and the regulations requirement, and then as and when it changes, that needs to be filed on the BO register as well. If there are no changes that happen, then the annual filing becomes applicable.
Okay, will the annual return process have a hard stop at some point to prevent filing of annual returns if a BO information has not been filed?
I don't think that this will be applicable to your annual return filing, so there won't be a hard stop in terms of this. The BO register will be dealt with separately. Filing with the annual return is just to make it easier for companies to tend to their governance in one step as a whole. But if there's non-compliance in terms of BO, then that will be dealt with separately. For example, you will have a situation where there is no beneficial ownership information, but the securities registers, etc., needs to be filed to prevent you from filing annual returns just because that wasn't done. I don't think that would be the relevant step to take. I think non-compliance in terms of BO will be dealt with separately.
Okay, then will you be triangulating with the DMRE?
Josephine, we will be triangulating with as many regulatory bodies and authorized entities as possible. So it's a process because they all have to get their systems in place. And you cannot just share data without getting anything back, and to ensure that the confidentiality and POPIA requirements, all of that is in place. So it's a process. It's not something that's going to happen overnight. But the CIPC is actively working with all these relevant bodies in order to triangulate data.
Okay, and there's a question. Any plans of IXBRL type of submissions of these registers via software partners?
That's definitely something that we've thought about as well. As I said, this is a very high level register just to meet the FATF requirements, at least from a CIPC perspective, and to get the ball rolling. A starting point, we are entertaining and discussing and developing every possible avenue that would make this process more seamless, easier, simpler for the filers, as well as the beneficial ownership team that needs to look at this data, and for law enforcement as well in accessing this data.
Okay, where a private, yeah, I won't say if this is a repeat, you must just say so.
Yeah, I've seen that one already.
Okay, so we can skip that one. Britannia, how will compliance be regulated and will it be able to check if a company is compliant?
Okay, so what we're going to start with as a beginning, there's a dedicated beneficial ownership team within the CIPC that is going to look at all of these submissions from our perspective internally. What we're going to do is verify the data submitted first. So we're looking at the uploaded documents. Is there an ID uploaded? Is it certified? Does it comply with the 3-month certification requirement? Is there a mandate uploaded? Is it signed? Does it triangulate with the company that beneficial ownership information is being filed for? That type of thing. So there's going to be physical validation of documents, and we're going to look at that and try to sift out if there's an error or something to allow the entities to correct that and to resubmit documents. So that's going to be the first step. Later on, as we go along and we're building enhancements and the team grow in terms of what we are looking at, we are going to do sample-based, risk-based analysis of the information that we are receiving. For example, all the NPCs to look at the type of information that the NPCs are submitting, triangulate that with the FIC, to see if there are any financial sanctions attached. All of those triangulations and analysis is going to happen as we go along. For now, we're going to look at the practical side of the submissions, do the documentations that were filed comply with requirements? If not, is there a way that we can correct it? Is it simply an error or is it deliberate provision of false information? And then that will be taken from there.
Okay, is the securities register a new requirement or has that always been there?
No, the securities register is a new requirement.
Person says, I don't understand in your comment that we must lodge now and then next year with an annual return. Do you know the information this year or do we need to lodge in line with annual return time periods?
It's very simple. Now the act became applicable. The General Laws Amendment Act that amended those 4 legislations that I mentioned became applicable on the 1st of April 2023. That's when the system was rolled out as well. So that's when we started asked everyone to voluntarily start filing all that information that is required in terms of the amendments to those legislations, specifically in terms of ours, the Companies Act. Once the regulations were promulgated on the 24th of May, this moved from on a voluntary basis to a compulsory basis where this information must be filed. So the whole of corporate vehicles registered on the CIPC records is required to file their beneficial ownership information, securities register, and beneficial interest information as applicable now. If that information changes 2 months from now, then there is another filing that needs to come in terms of beneficial ownership because it needs to be updated within 10 days from the change happening with the CIPC. If there is no changes happening on the beneficial ownership of a specific company, then there is going to be an annual update or a confirmation of, no, BO is exactly the same. Here's my shareholders is exactly the same. Here's a copy of my securities register. I do everything the same time with the annual returns, with the submission of the annual financial statements, with the beneficial ownership register filing.
Okay. This question, CIPC e-services still ask for ARs and I assume shortly also BOs for entities that have been deregistered years ago. How do we fix that?
Okay, that is a problem. If they are a finally deregistered entity that the system still requests annual returns to be submitted, that's not supposed to happen. And we're not going to request beneficial ownership information of an entity that's technically not active. So there's the user guide as well, gives an indication of what entities, even if an entity is in business rescue, if it's in deregistration process, all of that status still requires filing to happen.
Okay, I don't know if this is a repeat, but it says if a SA company has a foreign shareholder or foreign company holding shares, a complex company shareholding structure, do we need to get the shareholder, the natural person, details of a foreign company?
Yes, if there is a warm body of the shareholder of the foreign company being a shareholder of a South African company, and you were mandated to submit their beneficial ownership information, again, it remains that specific company's responsibility. We're not going to go after the filer, law enforcement, and the CIPC in terms of sanctions and criminal actions, are going after the companies themselves or the closed corporations, the corporate vehicle, so to speak, in terms of non-compliance. So when you receive a mandate to submit that information, then make sure that all the information is provided right down to the ultimate owner, the warm body at the end of the line.
Okay, in the case of an incorporated company, example, a law firm, where all the directors are shareholders and vice versa, as required per the Legal Practice Act. So no hidden information. We file the share register, correct? If there are more than 100 directors or shareholders, can we file a PDF extract of a share register? The securities register is an electronic register, for example, kept in Excel format.
Thanks, Gretchen. Yes, short answer is yes. The securities register is filed in PDF format. If your securities is being held electronically, there is requirements. The Act says that it needs to be accessible in a written format, basically. So that PDF extract of the securities register is perfect.
Okay, will there be any penalties now if it is not filed with the AR?
There won't be any, there's no penalties applicable to BO filing. And as I said, the annual returns register and the beneficial ownership register are separate at the moment. So the only sanctions of non-filing in terms of this legislation, as I said, is non-compliance of the Act and the applicable sanctions that flows from that, like compliance certificates, etc., if it's not done. But you won't receive a penalty on your AR if you didn't file beneficial ownership information, because the CIPC won't know if you have beneficial ownership information to file. And as I said, that securities register upload is separate from the annual returns.
Then is the BO linked to SARS returns?
No. The SARS will have and develop their own requirements in terms of beneficial ownership information that they would look for.
This person says, if you're unable to advise on legislation, how are we supposed to understand it?
I suppose that is where you appoint a lawyer to explain that. Unfortunately, I can only advise in terms of legislation in general. I cannot assist with specific scenarios put forward. Then we will be here until 4:00 tomorrow afternoon. So I'm not saying that we can't advise, but the CIPC again cannot provide legal advice. If there is assistance needed with this type of governance, then the appropriate assistance needs to be obtained, whether it be through auditors or legal counseling, whatever the case may be.
Okay, the next question, what documents are needed when lodging BO for CCs?
If there is a beneficial owners in terms of CCs, then that confirmation will be required. So in terms of a closed corporation, you will also have a members register. So you won't have a securities register because there's no shareholding, but you will have a members register, and that's the information that's uploaded.
Then when identifying that the entity is affected, the system still makes you to the BO page whereby personal information needs to be disclosed. This information is on straight. How do we finalize this application if we require to fill in information we do not possess?
The BO information isn't there. It requests the BO information. That's something again technical. You are welcome, Kaylee, just to submit that query to CIPC, but select ICT to ask them on that technical requirement. It's not supposed to request that information. Once the affected company box has been ticked, then there's no request for BO information that needs to be uploaded. It's then where the securities and beneficial interest information or registers is uploaded.
Okay, how do we determine what to disclose for public entities with shareholding in subsidiaries together with other legal persons?
Again, you have to ask, the company needs to provide you with that information, and you need to ask yourself in terms of complex structures, who is benefiting at the end of this line and who is in control at the end of this line. And that information is what needs to be submitted.
Okay, but both the CIPC and TRP has acknowledged the admin burden on private companies that have not elected code to comply with the provisions of the CHPT 5B and C. We need clarity of the affected companies.
Yeah, we understand the administrative burden, and that is why affected companies, if you are considered an affected company, the relevant tick box is done, and data will later be extrapolated with the exchanges, with Straight, with Computershare, and other similar authorities that hold that information, as to allow for entities not to duplicate submission thereof.
Okay, how do I sign up for alerts about the new or future notifications and webinars from the CIPC? Natalie, persons who are interested can send email to education@cipc.co.za. I must warn you though, we do send notifications most of the time, but there are times we slip up. So the best is to be following CIPC on Facebook, and as well as or subscribe to YouTube. But you're welcome to send your details and we'll add it to our list. Can I also jump in quickly and add one question, Ritzani, if you don't mind? I don't know if it's applicable or not, but perhaps you can also answer this one that says, what if an NPC is a homeowner association?
Is this now your question, Alma, or?
Yeah, no, it's a question from a customer. I don't know if it's there's any specific requirements for homeowners associations.
If that's corporate bodies, homeowners association, and a body corporate is usually NPC. It's specifically provided for in terms of the definition of beneficial owner, and that information needs to be submitted as well. Because if you're in a homeowners association as a registered NPC, you have members that's part of that homeowners association. So that information needs to be provided.
Okay, thank you. So just to confirm, if we have a basic PTY with two natural shareholders of 50% each, and they are the true owners of the shares, non-nominated, then you will still need to submit the return, upload the share or security register, but there is no need to submit the beneficial interest and ownership report and disclosure form.
Yes, so if there isn't any beneficial ownership information applicable and there isn't any beneficial interest information applicable, in other words, the issued securities being held on behalf of someone else, then it is the upload of the securities register that's required. Yes.
Okay, does anybody know when the actual due date for this is? Since the 6 months are not applicable, when will the penalties be issued?
The due date is not a specific date in time. The guidance note that was published on the CIPC website and the legislation, the regulations specifically indicate that this must be done 30 days from the anniversary date of the entity normally in terms of annual returns. For now, we want this information to be uploaded as soon as possible. So there is this requirement is actually immediate. In terms of penalties, as I said, this is not something where your penalties is uploaded the same as with annual returns, but there is the risk of non-compliance in terms of the legislation that could result in investigations and compliance notices issued. So just the best advice that can be given is to get, if you are the director, etc., of a specific company, then you are required to get that company's house in order, get your securities register in order. For example, that information already had to be updated, not with CIPC, but in terms of internally held by those entities. So the only requirement or change now is that information is to be submitted to CIPC, but it was supposed to be already held by the different entities.
Okay, then a worldwide corporate with a subsidiary in SA is ultimately owned by a family trust. None of the beneficiaries are involved in the business. Should the directors of a foreign holding company not be stated on the BO instead of given that they control the affairs?
The directors can be indicated on the BO system, yes, in terms of control, but the family trust and the beneficiaries, although not involved in the business, the question needs to be asked if they ultimately benefit from this ownership that they hold. And if so, they are regarded as a beneficial owner, and thus the information must be provided. So I saw another just popped up. There was another query that I saw on the side. If the 100% aggregate, for example, if there is a difference between the control and the ownership, the system was built in such a way that it will calculate the 100% aggregate with regards to voting interests, with regards to shareholding. So if you have beneficial owners to submit in terms of shareholding, it will only allow you up to 100%. If you have, for this exact same entity, beneficial ownership information to submit in with regards to voting interests or the control, then it will only allow you up to 100%, but it can be filed for the same entity. Sorry, Herman, I just jumped in there with another query. I hope your
it's fine. It's fine. With trust, where a class of beneficiaries are defined, it will be impossible to name the warm bodies. Example is class of beneficiary is all disabled persons. Am I correct in saying that only named beneficiaries must be declared?
It takes me again to my question on if there's a class of trust. Why is a trust set up if there isn't an actual warm body that's benefiting at the end of the day? If a class of beneficiaries is classified as disabled persons, in what context? all disabled persons, all types of disabled persons in the whole of South Africa, only persons that cannot see. All of that is supposed to be defined. And at the end of the day, there is a warm body that receives that benefit of the trust. Otherwise, that would be seen as I don't want to get into the legalities. I'm just going to stop there. But there is, for any corporate vehicle, there is a beneficiary, a person that benefits at the end of the day. And that is the information that must be provided.
Okay, could you please comment on instances where the shareholders of an external company is a foreign government and there is no warm body, so to speak, in the ownership structure?
The same applies as the previous. There has to be a warm body. Even if an external or a foreign government is the owner in terms of a company, there is dividends derived from the company. It's a business. There's property held by that company. Who's the ultimate owner? Who derives benefit from that? If it's a foreign government, then it needs to be the president or the king or the prince or whatever the case may be. I don't want to talk about things that I don't have facts on. Please understand that all of these, the question that you need to ask yourself is to look at that structure from beginning to end, break it down, and look for the warm body at the end of the line. There always is a natural person that derives benefit or controls at the end of the line.
Okay. Then will the power of attorney extend to the authority to submit the annual return or the BO only? Unfortunately, we have had the experience where some random individuals has erroneously submitted annual returns for our client, and we are unable to change it.
The mandate to file beneficial ownership will be applicable to beneficial ownership only. So we do not want a blanket power of attorney where it includes all filings to comply with administrative requirements. We want this, and the legislation is quite clear as well, that there must be a person that can be looked to when investigation in terms of this type of information. Not to say that that filer is responsible for the information that is being filed, but it is assumed that they received an instruction from this entity, and here's the proof of that. Remember, we're looking at law enforcement agencies, so they want evidence of these types of filings, and a company cannot throw up their hands and say that we didn't give permission to Lucinda Steenkamp to file this information on our behalf. So that beneficial owner information that you have there is completely incorrect. We don't even know who those people are. So they cannot claim ignorance if all those specific mandates are in place. So it's advised that it's not a blanket document, and there must specifically be beneficial ownership references in the mandate.
Okay, does all the BO supporting documents, mandate ID, security register, etc., need to be certified before uploading?
The securities register and supporting documents does not have to be certified. The only certification that we require is in terms of the ID, same with all the other process. So if there's any identification document, that must be certified in line with the certification requirements of the CIPC.
All right. At present, when we try to access the BO section on the CIPC site, the following message is displayed: your connection is not private. Attackers might be trying to steal your information from beneficialownership.cipc.co.za. For example, password, messages, or credit cards. How can you expect the public to access the site if there is no adequate security in place?
That message does not refer to the CIPC security, and there's nothing we can do. It says your connection is not private. So that could be have been accessed in terms of a mobile hotspot, which we all know is not safe or private. And I wouldn't advise beneficial ownership or any work being done using that type of connection. So if these type of messages pop up, I would advise that it's adhered to, because it gives you an indication that where you are connecting from might not be secure. Unfortunately, the CIPC is building every type of security that we can into our systems, in terms of hacking, in terms of firewalls, in terms of malware resistant. It's very technical. I don't know all the definitions attached to it, but if should you get something like that, I suggest you adhere to it. It means that the connection that you are accessing from is not secure.
Okay, please issue a directive, reference disclosure of trust ownership, example, known beneficiaries at time of filing when one is dealing with a broadly and opaquely defined class of beneficiaries in a trust, DD.
I'm not with you, Josephine. Please issue a directive regarding disclosure of trust ownership. Example, known beneficiaries at the time of the filing when one is dealing. Yeah, so again, I can only refer you to the Trust Property Controls Act, amended by the General Laws Amendment Act, and the requirements in terms of trustees, etc. I don't have insight as much as I should yet on the other legislations, but there's very specific requirements in terms of NPCs, in terms of trusts, that needs to be provided for. So I'm sure that queries with regards to classes of beneficiaries in trusts, that amendments in terms of GLRA will deal with those amendments as well.
Okay. How do you declare...
Sorry, Alma, I see a reply from Lorita from one of my team with regards to where they say that your connection is not secure. It might be a situation that they are not logging in through the CIPC e-services website. So in order for you to file beneficial ownership, you have to be a registered CIPC customer with a customer code and password in order to do the filing. So just have a look at that part as well. Thank you, Lorita.
Okay, how do you declare a company as a subsidiary of a local listed company? The regulations of the CIPC website state that the filing is not required.
Again, Herman, that would be for the company to ascertain whether they are a subsidiary of a affected company, and therefore also consider an affected company, and then filing the BO with the tick box in that regard. It's not for the CIPC to decide who are subsidiaries and who isn't. Once we start looking at the data that has been submitted, we will be able to ascertain whether the correct information was provided or not.
Okay, there's somebody else who also says Ms. Steenkamp is great. She really knows her stuff.
Thanks, Mandy. I think I need coffee at this point in time, but we're getting there. And you're welcome. We, as I said, we have a dedicated query resolution team on our inquiry system on the website. So if there's anything that we didn't deal with today, please feel free to submit your query. We will help you as far as we can.
Okay. Lucinda, yes, I think that's great that we remind customers they can send through their queries with a QRS, and specifically, well, there's the IT for technical questions on the system, and there's your side for the more legal type of questions.
A beneficial ownership category you will find under corporate legal when you submit the query.
Okay. So there's another Question, how do we disclose BO information when the subsidiary company belongs fully to a listed company? We can provide further BO information. Therefore, I cannot proceed with a BO application. Please do not tell me that the subsidiary needs to be disclosed. I realized that, but the system is not set up for this form of entity.
If the subsidiary, if a company is a subsidiary of a listed company, then they are regarded as an affected company and do not have to file BO information.
Okay. It's on. Are there more questions? Can you confirm listed entity and group of companies where the parent company is the owner and not an individual? Beneficial ownership in terms of BO definition, do we submit it if it's a juristic person?
It seems that we have to do here with the holding company and subsidiaries again. So it's for the entity to ascertain whether it's an affected company or not in terms of subsidiary information. But if the heuristic person is the ultimate owner of another heuristic person, there is still shareholders and warm bodies in control of that shareholding heuristic person, and that is the information that we need to get to at the end of the day in terms of BO.
Okay. Lucinda, I was under the impression it's Rutzani that's helping us with the questions, but apparently it was Lisbon Moniela. Thank you, Lisbon, for that. He's
Thanks,
indicated that more or less all the questions are answered. If we by accident skipped your question, please log a query as Lucinda indicated. And I can also say to the lady, I know she was Andrea, I see she commented again, I'll send through your comment. It was the one about the security problem. I'll send it to our ICT. Okay, with that then we've come to the end of our webinar. Thank you very much for joining us, and we hope it has been of value to you. And hopefully we'll see you in our next webinar. Have a great day. Bye-bye.
Thank you very much, everybody. I hope that the information was useful, at least. I'm sorry if I couldn't answer everybody's question. And just to the facilitators and the team that assisted in providing the questions and providing answers, thank you very much from my side.